So, how does one properly prepare to present themselves in court? And if you're a father or a mother about to head into court for a custody battle, you want to be sure and get this right because guess what? All that matters is what the judge thinks. Meaning, you can say all you want, your mom, your dad, all of your friends, your family, even the evidence, which is a really strong thing, can voice things in whatever way, but what matters is the judge. So how you present yourself is key. The number one thing you can do in all custody cases or divorce or anything is get inside a courtroom and watch. So watch family court. Now, if your state, county, or country, in fact, the person who asked this question lives in a country where they can't observe court proceedings, this is not an option. So the second best option is then to be able to talk to different attorneys. Talk to attorneys who are used to going to trial about the best ways to present yourself and if they have any information on how to do that. These two things are super important because they're in real time working with what that judge actually thinks. And of course, you want to see your judge or attorneys who have been in front of your judge. This then brings us to a couple of other basics, which are really important. So number one, just present facts. So this is important because all the evidence that you have, all the ways of presenting yourself need to be in the order of the court. So there's already a process for this. If you're in the US, go to the county clerk's office and ask for different processes, or if they have a packet, or if there's anything online that can help guide you on how to properly organize and present evidence so it matters to the court. If that's done wrong, a judge can shut it down and kick the evidence out of your case. And that evidence could be really relevant. You just didn't know how to prepare it properly. The other thing that I will say is this isn't an argument. It's only about specifically in the case. So a lot of times in custody, there's all sorts of grievances, complaints, or whatever. But if you're going in for a parenting plan, be ready to argue only the stuff that matters in a parenting plan. If you're going to try and get your protective order dismissed, it's really important to not bring up any of the parenting plan stuff and only talk about stuff that would disprove that you're guilty of what they're accusing you for in the protective order. What the motion is for, why you're going to the hearing, whatever reason you're in front of a judge needs to only specifically be talked about. I would also say answer things in yes or no questions. If you're asked to describe something, be to the point. If you're asked to break down a timeline, be to the point. Don't make all sorts of excuses. Learn how to be respectful and polite. Do not argue. Now, all of this is a ton of stuff and it takes a lot. And there's nuances with all of it. If you need any help with this, check out my different resources. And if you can afford my communities, come on by and we'll help you out.